All right, let's now cross over to the Court of Appeal live, where day 2 of the hearing. Final decision is expected to be given today after the hearing. Let's just listen in to the goings-on at the Court of Appeal.
Intervening action by the Electoral Commission from the moment the votes are announced and declared at the constituency level. There should have been another form that would then be signed by the chairman of the Electoral Commission or some super returning officer showing that the changes that were made by the Electoral Commission. There is no such opportunity for the Commission or its chairman to do that. And to that extent, my Lord, it cannot be said that the law as conceived in the Constitution would give the Electoral Commission or its chairman the opportunity to vary or alter or interfere with the results as announced at the polling station or the returning officer at the constituency. Now, I come to the issues that were raised by both the appellant and the Attorney General, and more particularly by the appellant, to the extent that they said that Article 138 of the Constitution in respect of a presidential election is self-contained. That cannot be true. First, the election of the president, just like any other election, must comply with the general principles for the electoral system, which are set out in Article 81. Secondly, in Article 136, sub-Article 1, which states as follows: the president shall be elected by registered voters in a national election conducted in accordance with this Constitution. A national election, but conducted in accordance with this Constitution. And it is this Constitution that talks about the elections being held in each constituency. And any act of parliament regulating the presidential elections. So the elections must be held not only in accordance with that article, but in accordance with the Constitution generally and an act of parliament regulating presidential elections, and that is the Elections Act. Now, as regards the construction to be made out of Section 1, Article 138 in relation to the impugned sections of Section 39, 2 and 3 of the Elections Act. My Lord, our submission is as follows. The functions of the Electoral Commission after the presidential elections has been held at the constituency level are clearly set out in that Article 138. My learned friend, Mr. Otinda Mola, alluded to this, but I'm coming to this in terms of an aid to interpretation in relation to Article 86 of the Constitution in relation to the voting, Article 86, And in relation to what is the responsibility of the Electoral Commissions once the election results have been announced at the polling station and at the constituency level. And this article makes it quite clear that after the counting the votes in the polling station, the Independent Electoral and Boundaries Commission shall tally and verify the count and declare the results. In our submissions, that is the two stages of elections at the polling station and at the constituency level. The tallying of the votes from the various polling stations, so that we could have a result for the constituency. This is my understanding and reading of Article 138, Subarticle 3C. And it says very clearly, after the counting the votes in the polling station, and there's a comma there, and my submission is that subsequent to the count of the polling station, the results are then tallied and verified in terms of the material which are made available to the returning officer, the tallying sheets and the declaration results at polling station. Now, what happens thereafter?
Senior Counsel, in
Yes.
5 minutes, you'll have done 45 minutes.
How many minutes?
In about 5 minutes.
5 minutes.
Yes.
I'm obliged. Now, there's a very important responsibility for the Electoral Commission once the elections have been held at the 290 constituencies. The tallying at the national level is required to achieve two objects. One, to determine whether any of the candidates have achieved more than half of all the votes cast in the election. That's a process that required some arithmetic from the material which is offered to the Electoral Commission at the National Tallying Center. From the 290 results from the constituencies, they can then establish whether any of the candidates has achieved more than half of the votes cast in the election. And B, that at least 25% of the votes cast in each of more than half of the counties. So they got to go through a process of verification, as it were. This is why I think the word verification is important, to verify whether that threshold has been met by a candidate who would then be declared as president. And you know, that section begins, a candidate shall be declared elected as president. He shall be declared elected as president when those two things are verified and confirmed. Not the results from, not confirmation of the results at the constituency level as received from the polling stations, but those results as relates to what is required under Article 138, sub-article 4. And then that if no candidate meets any of those thresholds, then, my Lord, there will have to be a fresh election or a runoff in terms of the two top candidates. Those are the things which the Electoral Commission is supposed to determine and verify at the National Tallying Center. And that's why the work of the chairperson is so simple. It's not about figures. At the end of all this, is only one statutory instrument that is supposed to sign who has won. No numbers, no figures, just who is declared to be the president. It doesn't need to say he won by so much. The Electoral Commission, in the person of the chairman of the commission, then declare the result of the election in terms of who has won the election. My Lord, in conclusion, I want to say this. Since there was a reference to Kriegler report, for those who are involved, and my learned friend, Ms. Dr. Otinda Mola is here, the Attorney General was there. Part of this chapter dealing with elections, chapter 7, the representation of the people, a lot of material that was used in crafting this chapter of the Constitution came from the recommendations or the observations in the Kriegler report. There's a general commentary in that report about our electoral system and its flaws. And this animal called provisional results came about on the basis that at that time, before you can achieve an electoral system that answers to the general principles that are stated in Article 81, because as observed by my learned Judge Morgo yesterday, this inflation of results as they left the polling stations and going to the constituencies, and finally to the National Tallying Center, that in order to address the mischief of the ballooning of results or the decreasing of the results, you would have a provisional result that is transmitted. That is in the regulations. So that when finally you have these statutory reforms in the National Tallying Center, there will be a verification whether what has been transmitted electronically agrees.
You left me somewhere hanging. You said something on the Kriegler report, part of the chapter dealing with elections. A lot of material used came from what?
Yeah.
You went back to my Kriegler. I didn't quite get.
I'm saying the design of this chapter, yes, or representation of the people.
Yes.
The general principles and the procedure for elections came from the recommendations made by the Kriegler report. But my Lord, if you look at the report, he did suggest that as an intervening solution, before we get there, you needed to have a provisional result transmitted electronically, so that if, for example, in station X, results were announced, which then increased when they got to the constituency, and finally at the National Tallying Center, you'll be able to compare the results as transmitted from the polling station and as borne by the statutory documents that would end up at the National Tallying Center. And that's why it was called provisional. And if you read the judgment of the Supreme Court in the Raila Odinga case, it was the position of the Supreme Court that provisional result as transmitted electronically were not part of the mandatory provisions of our electoral system. I think that is there. And I think Section 39 of the Elections Act tended to retain that proposition by Kriegler, which was an interim measure, and then turn it into part of the law of the land in relation to the elections. So in conclusion, my Lord, from all that we have said, including what my learned friend Willis Otieno submitted yesterday, in totality, should find favor with the court to come to the same conclusion as the High Court in finding that Section 39, subsection 2 and 3 of the Elections Act and the impugned regulations are inconsistent with the Constitution.
All right, the hearings there at the Court of Appeal on whether the presidential poll should be declared final at the constituency level or here by Chebukati, the chief returning officer. That is a big story we are following up on today. And remember, here in Worldview, we also ask you whether you believe the presidential poll should be final at the constituency level. A number of comments I'm getting here. I'll just sample one or two. Mike Tor says no, it can be easily manipulated. Malaga Jr. says yes, if governor, MP, MCA, women rep and senator are announced there and found to be credible, why not for president? Let the chairperson declare the winner. Said Gatibaro says it's not about who counts the votes at the constituency level, but rather who tallies those results and announces the winner. And finally, Kayando Christopher says it should be final this time round. No monkey business. Thank you for engaging with us on Worldview. Betty Kialo comes in next with News Center. But before she gets in, let's just take you back to the court.